have an immigration question or you want to file an immigration case, you should definitely consider attorney Adam Malik. Mr. Malik has worked as an immigration officer and has a unique experience, and the best part is that he speaks Hindi, Punjabi and Urdu as well. But his office also handles cases involving divorce, family law, child custody and child support. His new office is conveniently located in Carrollton, Texas. You can call Mr. Malik at 214-881-2100 or visit him at malik.law. And with us we have Mr. Joe Powell from the Malik Law Firm, and he's going to answer all your family law related questions today.
Well, I've got a few things that I can talk to people about, but
Sure.
I would welcome people to call in with questions. Don't hesitate to interrupt me. I'm just going through some things that might be helpful to people if they're not thinking of a question at that time. I don't, however, do immigration law, and I can't answer questions about that. I've never practiced in that arena. That's Adam's very highly skilled area of expertise. But I thought I'd begin today, until somebody calls in. I'm using an article from the 2019 Advanced Family Law Seminar, and it's titled "Scary Mistakes Lawyers Make," but I thought it might give people that are involved in family law some ideas or strategies that they might discuss with their attorney if they've got an attorney, and maybe bring these things up to them. They may actually help their attorney present their case more adequately. And the first one is that in the modern era, especially since 2021, there's discovery in virtually every case. Now, in some cases, the two attorneys will get together and they will waive required requests for disclosure, which are required by statute to be filed within 30 days of when the opposing party answers in a lawsuit in family law. Requests for disclosures are kind of a combination of requests for production and requests for interrogatories, which are just questions. But the thing about requests for disclosure is people cannot object or fail to answer requests for disclosure. They are required, and no objections can be raised. Well, it's okay for people. Some people have 30 days after the opposing party files an answer to respond, and sometimes that 30 days goes by pretty quickly, and people are busy, and so sometimes it's necessary for an attorney to request more time. The caution I'm making for people to talk to their lawyer about is make sure if your attorney needs to ask for more time, that they not only ask for more time to file responses to the requests for disclosure, interrogatories, or requests for production, but also require or request more time to file objections to discovery. Because if objections to discovery are not filed within that 30-day period, they are waived. Now, I personally don't necessarily raise a lot of objections because getting into discovery fights is expensive and can be time consuming, and generally the courts are going to make people answer the questions anyway, questions or produce documents that have been requested. So I only raise objections when somebody is really out of line and they've asked a question that's not relevant to the lawsuit, or in some manner it really needs an objection. Otherwise, I encourage my clients to fully answer the request for production, request for disclosure, and interrogatories. But the point I'm making here is that if you need to request more time, encourage your attorney, discuss with your attorney the need to request more time for objections as well as the answers to the materials themselves. The second piece of information, if a person is in trial, they are allowed to refer to notes. They can look at their cell phone. They can talk about texts that they've received on their cell phone. They can look at documents that they've gone over with their attorney. However, if they review documents on the stand, the opposing counsel can look at those documents. They can look at that cell phone. So the caution is, don't review a document on the stand that you don't want to show to the opposing party. So this is something that, even though it's your attorney's responsibility to know these things, some people are working with attorneys that have just gotten started. They don't have a lot of experience, or the attorney may have forgotten in a given situation if they're real busy. People don't remember everything. So people can take a little bit of action in regard to their own case and talk to their attorney about looking at notes or reviewing documents while they're on the witness stand, because the opposing party, the opposing attorney, will be able to look at those documents. Same with text messages and stuff. Another thing that I encourage people to discuss with their attorney is, in court, is their attorney going to raise a lot of objections? Sometimes judges will get irritated if an attorney is raising one objection right after another. And this is something a lot of young attorneys that don't have a lot of experience kind of fall into, because they're working from their law school experiences and they haven't had a lot of attorney working with judges. And the fact is, you don't ever want to irritate a judge if you can avoid it. So it's important for your attorney to raise objections when they're necessary. Like if your opposing counsel is going into things that are actually hearsay, statements made by a witness or made by a declarant to prove the truth of the matter. But if somebody's asking questions that have to do with something someone else has said, unless that person is a party to the suit, a hearsay objection may be appropriate. So it's appropriate for an attorney to raise objections when they're necessary, but a person should maybe caution or discuss with their attorney maybe not raising too many objections to where the judge begins to be irritated by it. And a witness can watch the judge while they're talking. The witness can certainly try to get a feel for whether the judge is responding well or not so well to the way that the case is being presented. Now, I'm not trying to get anybody in trouble with their attorney, and I'm not trying to get anybody in trouble with the judge either. But I'm just trying to give people some ideas that they might wish to discuss with their attorneys, and they can be more informed if they think through some of these things before they are actually put on the stand. Another thing I'd like to mention to people is that their demeanor, the way they present themselves, can rub off. The attorney's demeanor can rub off on the client, and the client's demeanor can rub off on the attorney. Sometimes a client's body language can lose a case. So discuss with your attorney before you go into court if there are things that you should avoid with body language. Sometimes something as simple as crossing your arms can be blocking out other people and might be something that a judge picks up on and doesn't see very well. So talk to your attorney about how you should hold your body and how you should conduct yourself in court. Now, I'm going to give everyone the Joe Powell simple 5-step witness preparation program. I'm just throwing this in an aside. This isn't part of this article that I'm looking at. And that is, I tell every client, listen to the question. Make sure you understand the question. Answer that question and stop. Don't explain, but if you need to explain, say so. In other words, you don't go into the explanation because that takes some power and control away from your attorney. But you can tell your attorney, I need to explain. I'm going to give a kind of a wild example on that. Let's say the opposing attorney says, have you stopped beating your wife? Well, first of all, you should give your attorney time to an objection, because there's an objection to that kind of a question called assuming facts not in evidence. Objection, Your Honor, the opposing attorney is assuming facts not in evidence. And if that's sustained, that question goes away, at least for the time being. The attorney may rephrase it in such a way that it avoids the objection. But it's important for people to remember that little 5-step witness preparation program, because if you listen to the question and you answer that question, one of the biggest mistakes witnesses make is they tell their story the way they want to tell it, and they don't listen to what question has been asked. That will receive an objection non-responsive. If you're not responding to the question that's been asked, the judge is going to shut you down. Now, that may not throw your case out of the window, but you try to conduct yourself so that objections are not sustained. So listen to the question, make sure you understand the question, answer that question, stop, but if you need to explain, say so. The opposing attorney will probably not let you explain, but your own attorney can write down in his notes that you need to explain that question, and they should write that down. They may or may not come to it because your attorney will make some decisions on what things should be gone into when you're giving testimony. That's what your attorney's paid to do. Now, you want your attorney to do a good job with that. And if you've got something that you really feel like is important, you really should talk that through with the attorney before the hearing. If there's some things that you definitely want to get out in your testimony. But your attorney may have some suggestions in regard to that are completely different from what your thought process lent itself to. One of the best examples, sometimes it's appropriate for people to bring up infidelity to a family law judge. There are times when it has an effect, but the judges hear so much of that if you're just airing your dirty laundry, you're just wanting to be heard, you just want to get your complaints out and tell the judge how rotten your spouse has been to you, that could backfire. Talk to your attorney about it. And the fact is, you need to take into consideration that a lot of times judges get really tired of hearing about that stuff because they hear it on at least half of the cases. The fact is that it's very hard to present that kind of material without your anger coming out, and that may have an effect on the judge's perception of you. So you've got to take those things into consideration. Talk to your attorney about how to present that kind of material, what kinds of questions you might be able to answer without showing too much anger. It's okay to show some emotion in court, but I'd like to talk about emotion a little bit. In family law, there's an old saying that's kind of a joke, but it's not really a joke. And that is, for every motion in family law, there's an equal but opposite emotion. And there's some truth to that. A motion is something filed with the court about what relief you're wanting, but emotion comes out in family law cases frequently. Now, I've told clients, if you shed a few tears on the stand, that's not a death sentence. That's not necessarily bad. If you show positive emotion or justified emotion when it's appropriate and you show it in an appropriate way, it's okay, but you don't want to overdo that. I think I'll talk to people a little bit about social media. Social media has become such a big, big part of our lives, and it comes up frequently in family law. And what I wanted to talk to people about is, sometimes people love to take pictures of celebrations, and that's great. Celebrations are a wonderful part of life. But a person should be a little bit careful about what they present on social media. I've gone into court and had opposing attorneys start showing social media by my client that they haven't let me know about. A second Facebook page. You know, you can have 5 or 6 Facebook pages if you want to set them up. So if I'm looking, I try to review social media with every client and look at their social media myself and see if there's anything that might be a trap for the unwary. A good example of that is I have seen social media where people celebrate the use of marijuana. Well, if you're in Colorado, you're probably safe with your presentation of marijuana if you're in a Colorado court. But if you're in a Texas court, Texas has not legalized marijuana. They may have softened the way they enforce it, but the Texas judges consider marijuana to be a significant issue. Same thing with alcohol. If your social media presence shows that you consume alcohol to excess, maybe you're a little tipsy in a social media video, you've got to take those things into consideration. Now, your attorney can deal with those things, but they can deal with those things much more effectively if you discuss that with them. Always tell your attorney the bad stuff. I had a case recently where a client went in and was basically ragging on their spouse about the use of marijuana, and they told me they didn't use it. Well, unfortunately, they did use it. And of course, their spouse knew about it. They used marijuana together. They had pictures and whatever showing the mutual use of marijuana. So my client looked like an unfair person persecuting her spouse for the use of marijuana when she used it too. And she specifically told me that she did not use it. So I'm not condemning anyone, and if that client happened to tune in, we got past that. We got through that just fine. But it can create some problems. So be very, very careful with social media. Now, I have a Facebook account. My wife uses it a lot more than I do. She loves to take pictures. And she's from the Philippines, and a lot of the things that she writes on the Facebook pictures and stuff is in her native language, Bisaya. She's from southern Philippines. Well, a lot of people are unaware that most social media, including Facebook, has translator software. You can translate most statements made. Now, Visaya is not a real well-known language, so it might not be available in Facebook, but a lot of languages are. I guarantee you Spanish is. So a person needs to be very, very careful, even if they're speaking in a foreign language, because the translator software may tell an opposing attorney or the opposing party exactly what you were getting at, and if there's some things that don't look very good, they may come out. So be very, very, very careful with social media. Be careful how you use it. Be careful who joins in with your social media use. Just be aware that if a divorce happens down the road, it may be fair game what's on your social media. Now, the next thing I'd like to talk about, if nobody has a question, feel free to call in. But when I draft a document, I always give it to my client to review. I had a case today where my client caught a lot of errors in, his name is very complicated. It's like a four long word name, and I had misspelled some of his name. Well, it's an honest mistake, and I'm a pretty good typist, but I'm not a typist by trade. I'm an attorney by trade, and every once in a while I'll type a typo. I frequently will type a word like count, and I'll end up saying county because I use county so much when I'm typing. So I'll write an account, and it'll be a county because I'm so used to typing that. And in this particular case, his name had some letters in it that were different in most English words that were similar. And so I put a G in his name when there shouldn't have been one. And I apologized for that, and I made the correction, and it was an easy correction to make. It didn't do any harm. We hadn't filed anything yet. But you as the client should review and actually read every pleading, every decree. I realize that a divorce decree where children are involved is probably going to be more than 50 pages long. And you don't like legalese. I understand that. But you should read every single paragraph of your divorce decree because you are going to have to live with it when the judge signs it. And if you don't read it, you can't discuss your questions, things you don't understand, or possibly language that's in there that you really don't want in there. What if your decree says you're able to pick the residence of the children, but it's restricted to Dallas County, and you and your family is from Wisconsin? It may be that you want to fight to not have a geographical restriction in that scenario. If you need your family's support in order to survive, you may need to go to Wisconsin. Well, depending on what your divorce decree says, you may be able to go to Wisconsin because you have every right to go anywhere you want to, but you may not be able to take your children with you, even if you are the primary custodial parent. And by the way, Texas doesn't use the word custody. They use the word conservatorship, but everybody thinks in terms of custody. I have probably half of the clients that come in to see me say, I want full custody. It has no meaning in Texas. And by the way, most judges aren't going to give one person custody and leave the other parent out. That doesn't happen very often. It can happen in extreme circumstances. It can happen with abuse. It can happen with mistreatment of children, negligence. There are things that can create a person not getting any access. But in Texas, there's a presumption that both parents will be joint managing conservators. The other parent's not going to be left out just because you have the right to establish the residence. Now, I'll tell you that judges more often than not will order a geographical restriction. They try to be reasonable. So if a person needs to not have a geographical restriction, they need to work with their attorney and come up with some very, very strong reasons why no geographical restriction is necessary. Okay. Now, let's say that you're working with your attorney and somehow a case inadvertently gets dismissed by the judge. Your attorney can get a dismissal reversed, but it has to be requested timely. So if anything like that happens, jump on your attorney quickly, work with your attorney to get a response quickly to get a case that's been dismissed, for example, reinstated. You don't want the case to go out the window because, number one, if you have to refile it and it's past the appropriate time, you're going to have to pay all the filing fees again. You're going to have to serve your opponent again. You're looking at an extra $500 that can be avoided by a quick response to a dismissal. And by the way, most counties have an online website, and you can look at it just like your attorney can look at it. You can look and see the status of your case in most counties. Certainly in this area, Collin County, Tarrant County, Dallas County, and Denton County, which are the counties I tend to work most often, those counties all have county online websites. In Tarrant County, I can print every document that's filed in Tarrant County. Now, that's not as easy to do in some of the other counties. So keep yourself posted. Don't just sit back and let even a skilled and conscientious attorney work alone. You need to work with your attorney. It's very, very important that you stay active in your case. You pay attention to your case. I had a client call me an hour or two ago talking to me about some things I had promised to do by January 9th. Well, she had the good sense to give me a call and see where I was on that, and I kind of had to be reminded of where we were on the case so I knew what I needed to do. We've got no problem, but her giving me a reminder was very, very helpful. I never mind a call from my client checking on the status of their case. That's my job. And I may have to ask you, what were we doing the last time we spoke? Because I am working on 25 to 50 family law cases at any one time. And a lot of these cases have very similar fact patterns. Please keep that in mind when you're dealing with your attorney. And different attorneys have different approaches to situations. So if I'm representing you and I'm not going the direction you want to go, you have a right to discuss that with me and either get me to come more in line with what you're wanting, or get me to explain to you why we need to go my direction on that. I give people the good, the bad, and the ugly. I don't lie to my clients. I don't tell my clients what they want to hear. When there are difficulties, when there are problems with a case, I discuss it with my clients and I discuss it truthfully. I tell clients every day in a given situation what I think a judge will do. I'm not predicting the outcome of their case. I'm telling them what could happen, good or bad, so that they're prepared for both the good things and the bad things. And if your attorney doesn't look at the other side's case and try to understand the arguments that are going to be made by your opponent, they're not doing their job. And if they don't discuss that with you and tell you some of the things that could happen, could come up with in court, then they're not doing you justice. Do everything in your power to keep your children out of the family law case. Now, with older children, 16, 17 years of age, you might have some leeway in discussing a case with them to some extent, but judges tend to very much not like it when you discuss a case, especially with children under 12. And I tell my clients, never ask your children to choose between their parents if there's any way to avoid doing that. You're asking your children to decide between usually two people that they love. Now, one of the people may have some problems. That is frequently the case in family law. But children tend to love both of their parents, and they tend to tell each parent what they want to hear. Their children are very, very good at that, and they get in that habit. So maybe I'm closing with this if we're out of time. Try to keep your children out of a family law case. The judges will appreciate that. How we doing?
All right, thank you, Joe. We are in the last 30 seconds of the show, and I want to take a moment to appreciate you and thank you for your insight, for sharing your insight and your research with all our listeners. And thank you so much for your time.
You bet. I always enjoy it. Thank you.
Thank you, Joe, and have a good evening.